Welcome to Lecture 7, Video Lecture 7. We're now more or less halfway the course, and this is the case in time, but also in terms of content. Because we're going to make a shift today. We're going to move away from the more procedural aspects and aspects about principles, the legal procedures of judicial protection and so on, and the more formal part, you could say, to the substantive part. So that's starting today. So what we're going to do now until the end of the module is we're going to look at a couple of key policy areas or key areas in which the European Union is active and what the European Union's main, let's say, policy fields, main orientations are. So moving away from the procedural part, what kind of procedures exist, to the substantive part, what kind of policy areas is the European Union's core business. Now, we could talk about dozens of areas, but we focus only on the very important core areas. So that's the free movement of goods, services, persons, and not capital, we left that one out, and competition law, we did put that one in. Yes, so now this week we're going to start with the free movement of goods, and in the following weeks we'll look at the free movement of persons and services, and then at the end we will look at competition law, some elements, some aspects of competition law. So, very clearly, the four pictures on this first slide, they represent free movement of goods, three or four forms of transporting goods within the European Union. Well, the big sea containers are usually further away to other parts of the world, but still very clearly moving goods. The train, the freight trains, the trucks, of course, a major source of transportation within Europe, and the airplane. So we'll start by going into the basic conditions for having a true internal market, because remember, that's essentially what we are talking about, an internal market. So basically having one open market without borders within the European Union. And then we'll go specifically into some examples. Well, not some examples, the key pillars, I should rather say, of this internal market by discussing them separately. And we will also involve the TFEU articles there, of course, and, very important, case law, court cases of the Court of Justice of the European Union. We'll start with the so-called CEEs, charges and duties with an equivalent effect. Then we go to prohibited taxes, and then finally to quantitative restrictions and measures with equivalent effect. So, as you can see, it might look a bit difficult, technical, so it needs some explanation, so this video cast might be a bit longer, but I'll try to squeeze it into 30 minutes. So what are these basic conditions for having this internal market? Now, if you look at the three boxes at the top here, there you have them. So there shouldn't be any internal custom duties. Remember, if you transport a good from one country to the other, you get to the border, it's very common that you have to pay a custom duty, so you have to pay money for importing the good. This is still common practice everywhere around the world. If you are in the United States and you transport goods to the European Union, you will have to pay custom duties, and the other way around. Now, the idea is that within the EU, this doesn't exist anymore, and that is indeed the case. The second condition is that you have no financial charges, other financial charges, that may hinder this free movement of goods. So you may say, okay, we have no internal custom duties, but we do have certain import tax, or we have inspection fees, we have whatever. And in practice, this can also be a hindrance to this free movement of goods. And so also other charges shouldn't be there. And then finally, you should not have, and that's number 3, any quantitative restrictions on the import or export of goods. So a quantitative restriction is a certain limitation of the quantity of goods that can be imported or exported. And so the first two are about money, and the last one is about quantity. Now this is in a nutshell everything we're going to discuss today. So if you understand this, then you understand the free movement of goods. Of course, you need to be able to back it up with the right articles and the right case law. And you need to be able to recognize in a specific case whether there's a financial charge being imposed or an equivalent charge to a financial charge, or a so-called MEQR that I will explain in a minute, a quantitative restriction or a measure equivalent to that. And then you understand the topic. In legal lingo, you can find the conditions in Article 26, 30, 34, 36, and 110. So these are some of the key articles that we will be referring to today. Let's start with the charges and duties with equivalent effect. So we'll start with some key elements. What are the key elements of this article? Well, the article is actually in the second box, so we can have a look at that first maybe. Custom duties on imports and exports and charges having equivalent effect shall be prohibited between member states. This prohibition shall also apply to customs duties of a fiscal nature. Now, if you look at this article, and by now you are almost trained lawyers, you immediately see that this is a very forceful, a very compelling article, because it uses the word shall twice. And so, customs duties, blah, 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 shall be prohibited between member states. In other words, the member states have to do this. They cannot ignore this article. They must comply with it. You see there's a distinction being made between custom duties in the strict sense, so clear custom duties, and other equivalent transactions that have the same effect. And also custom duties that are of a fiscal nature, so have the form of a tax. That's the article. I think it's quite clear. The first box emphasizes, and this is also based on European case law of the Court of Justice, that it should be about a pecuniary charge. So pecuniary, difficult word, is from Latin, pecunia, and pecunia means money. So it really has to be about money. The amount doesn't matter. Also very small charges fall under this definition. The third box, a charge having an equivalent effect, is a charge that may be named differently, but in practice has a similar or the same effect as a financial duty. That's a further explanation of these equivalent transactions. And some examples that you can think about are charges imposed only on the importation of goods, or both on domestic and imported goods, or only on exported goods. So there are different forms of these duties that you can encounter. A definition. I said already that the amount is not relevant, so even very small amounts are also covered by the definition. And this was decided in the case Commission versus Italy of 1968, where we have a clear definition of a charge with an equivalent effect. So let's look at the definition. A CEE, charge with an equivalent effect, is any pecuniary charge, so it's about money, however small in whatever its designation, so whatever it's called, and mode of application, so however the state applies it, is it via the custom authorities or via the tax office or via the government, local government or central government or anything, which is imposed unilaterally, so from one side, from the state side to the party importing the goods, on domestic or foreign goods, by reason of the fact that they cross a frontier, and which is not a customs duty in the strict sense. So what we see here is that this definition very clearly defines and covers all the situations that you can think of where member states would be creative enough to design a system where they levy custom duties, give it a different name, for example a statistical levy, as it was the case in this Commission versus Italy case. We need to charge this money because we want to have good statistical data on all the goods that are coming in and out of the country. So it's not a custom duty, it's a statistical levy. But if it complies with this definition, it still is illegal according to this article. Yeah, so what you see here is how the court is an example of how the court has woven a very strict web of case law to really make this internal market function and to really basically make it impossible for member states to come up with alternative systems of to dodge the official rules. Now, can charges then never be applied? Unfortunately, you know now that in law there are usually exceptions, and here we also have exceptions. So the rule is the rule, but there may be some situations in which you can have such a charge. But in essence, you need to have a very good reason for it. So, if the charge constitutes payment for a service in fact rendered to the economic operator of a sum in proportion to the service, yeah, that's an example of when such a charge can be levied. So, for example, if I import meat from Germany to the Netherlands, I arrive at the border, my meat van is broken, my cooling, and I ask the state, the Dutch state, to help me with that, and they supply a cooling room for my meat, a freezing room, and then they charge me for that. Then of course that is allowed, as long as they charge me a reasonable proportional amount. By the way, the proportion element, the proportionality element, is very important in all what we're going to discuss today, and also in many other things that have to do with law. It's a very, very common principle that is being used, proportionality. And so proportionality has different meanings, but mostly it means that there is a reasonable proportion between the means that are used and the objective that has to be attained. Or in this case, the sum, the amount of money that's being charged, has to be proportional to the service that is actually rendered. Yeah? So you cannot ask an excessive amount for storing the meat. Another example is that a charge can be applied for inspections and fulfillment of mandatory EU or international legal requirements. Now here you can think of some veterinary, yeah, I think so, veterinary, sorry, disease, so animal disease, that's actually easier, where there's a danger, it's a contagious disease, there's a danger that it will spread to other countries, so at the border a member state installs a check, and there's authorization from the EU or another international institution from the UN level, for example, that authorizes these kind of inspections, and again, of course, this needs to be proportional, so the money that is charged needs to be proportional. Alright, then we go to the next version of money pecuniary charges, and those are the taxes. So again, some key elements. Let's start with the article again to keep the same approach, the same rhythm. So no member state shall impose directly or indirectly on the products of other member states any internal taxation of any kind in excess of that imposed directly or indirectly on similar domestic products. So here again we see that there's a non-discrimination element, and so there shouldn't be any discrimination, direct or indirectly, between domestic and foreign products. And also the imposition of the tax can be either direct or indirectly. So again, it's an article that tries to encompass many situations where taxes can be raised. The first box, remember that imposition of tax, so tax systems are national competences still. And so there are some exceptions, but the key is that member states are responsible for setting their own taxes. Yeah. So by having this authority, it's also, of course, an opportunity to use these systems to discriminate and to block free movement of goods, of the free flow of goods, and to discriminate against goods of other countries. So that's why there's a separate article for it. Third box, tax systems need to comply with the non-discrimination principle. Well, we already talked about that. And this discrimination can be direct or indirect. Now, of course, the discrimination is never direct. That's too obvious. So the situations you have to think of here are indirect discrimination cases. And an example could be, and we'll discuss this further, I believe, in the seminar. If not, remind me. That there's been a case in the past where there was a tax system in France that had a certain tax percentage on car engines, and it had a system where the smaller engines had gradual taxes that increased, and the bigger engines had an exponential increase in tax. So there had a huge leap in taxes there. Now the funny thing was that the cars with the smaller engines, so with the lower tax rates and the gradual tax rates, were all produced in France. They had car industries there that produced relatively smaller engines. And the bigger engines, those cars that were of course hit much harder by these exponential tax rates, they were produced mainly in Germany, abroad. So that's a very clear form of indirect discrimination, because the rule didn't say cars from Germany will be taxed higher or cars from whatever country. No, it said the size of the engine is important. That's what we look at. So we don't discriminate between countries, but we only look at the size of the engine. But interestingly, French cars all had these small engines and German cars had the big engines. So this is how subtle these systems of discrimination can be. Okay, can a tax never be applied? Of course, here again we have exceptions, and what is important is that it can be justified objectively, and so an imposed tax can be justified with a good criterion, for example, protecting the consumer or protecting the environment. So in principle, the example we just discussed, the tax on the car engines, that's in principle not illegal. Countries can have systems where they tax engines. In the Netherlands we also have these kind of milieubelasting, as they're called, environmental tax. But the problem starts existing, of course, when you make these kind of strange distinctions that hit one country much more than the other, for example. So that leads us more or less automatically to the next point. The tax must always comply with the proportionality principle. There we have it again, proportionality principle. Proportion, it has the word proportion in it. There should be a reasonable relationship between the objective pursuit and the height of the tax imposed. So again, if you want to impose tax for environmental reasons, make sure it's still has a reasonable there's a reasonable distinction. Now there's a reasonable link between what you want to achieve and the tax that you impose. The height of the tax should not be excessive. Then we go to the last part, and this is where we leave the pecuniary charges, so we move away from the money charges that may limit the free movement of goods, and we go to the quantitative restrictions and so-called MEQRs, measures with an equivalent effect to quantitative restrictions. So here it's about actually saying you can only import a certain number of goods and not more, or not at all, you can't import any goods. We find the basic article, the basic rule description that this is not allowed in Article 34. So again, starting with the article, quantitative restrictions on imports and all measures having equivalent effect shall be prohibited between member states. Alright, now this is a complex set of words. Basically, a quantitative restriction is a restriction in number and quantity, and any other rule that has a similar effect is also not allowed. Again, a simple article, we have a similar article for the exports. You can see it in Article 35, I believe. So an MEQR is a measure with an equivalent effect to a quantitative restriction. This is a very important concept, and it's so important that we can actually, at the exam, if we would ask you about this, just put the abbreviation there. So we ask you, is this an MEQR? And say whether or not it is justified. Yeah, so be prepared. So, quantitative restriction, third box, can be anything ranging from a quota, a limitation on the number or total weight of products, to all out import or export bans. I think that's clear. MEQRs usually come in the form of national laws. This is also very important. I will explain that more in a second. or other rules of member states that in practice have a similar effect as a quota or a ban. In other words, they strongly, I would say, restrict the free movement of goods. So these national laws, this is very often the MEQR. So there's a national law in this or that country that says that certain product characteristics need to be complied with, and otherwise the product cannot be put in that market. Then the question is very often, is that particular law in that country, is that an MEQR? Yes or no? And if so, can it be justified? So, MEQR. We saw Article 34, so we know that it says that there's a prohibition of these MEQRs, but it doesn't say what it actually is. So a very important piece of case law, again, very important, we expect you to know this case, to be able to use it, is Dassonville, because Dassonville was the case in which the Court of Justice of the European Union defined what an MEQR is. Very briefly, what the case was about. We see whiskey here, and we see a picture of Scotland and Ireland and England, Wales and France. It basically depicts, in Belgium, it depicts what the case was about. It was the Dassonville brothers, and these were Belgian brothers, and they had a shop or a business in which they sold strong spirits, such as whiskies. Now what they did is they imported their whiskies from France. So these were Scottish whiskies and Irish as well, but they bought them from France because it was somehow cheaper for them. This is called parallel import. Yes. So the whiskies were not produced in France, they were real Scottish whiskies, but they were sent first to France, and then the person in France resold them, sold them on to the Dassonville brothers. Now, back then there was a law in Germany. Remember what I said about the MEQR is usually a law. So there was a law in Germany. Sorry, not Germany. There was a law in Belgium, because the Dassonville brothers were in Belgium after all. And that law said that you could only sell whiskies with a certificate of authenticity of the whiskey. So this certificate was only issued by the Scottish producers. But they had already been issued when it was sold to France. In other words, for the Dassonville brothers, it was very difficult to get these certificates. So they were selling the whiskey without their certificates, because they didn't have them. Now, the Belgian law said that this was illegal. The Belgian law said you cannot sell whiskies without these certificates of authenticity. And the Belgian brothers, Dassonville brothers, were prosecuted for that. So they got into trouble with the Belgian authorities that said, listen, you're selling whiskies that don't have certificates, and we can't say whether they're authentic, but therefore this is dangerous for the consumer. We have to protect the consumer, so we're basically closing you down, or we're imposing a fine or whatever. Now I hope you see and that it's clear that this is of course a danger to free movement of goods, this Belgian law, because it actually makes it more difficult for the goods to flow freely, because they can't really flow anymore from France to Belgium, at least not these whiskies. And that's why this case was so relevant to the interpretation of Article 34 and the free movement of goods. The definition that the court gave of MEQRs is, and we see it on the slide, all trading rules enacted by member states which are capable of hindering, directly or indirectly, actually or potentially, intra-community trade. Yeah, so all these rules are to be considered measures with an equivalent effect to quantitative restrictions. So what we see here is again a very broad definition that the court created. And again, in order to have a kind of a safety net for all these situations where member states could come up with local laws or rules that would restrict free movement of goods without having good reasons for it. Yeah? So an important definition that we expect you to be able to use and know, at least at the exam and hopefully also afterwards if you have good memories. Okay, again, we follow the same system. We established that there's a rule that protects the free movement of goods. We say it's not allowed to have, in this case, quantitative restrictions or restrictions with equivalent effect. But is it never allowed? Are there never exceptions? Again, yes, there are exceptions. And the first exception we can find in Article 36 of the TFEU. And it says there that you can justify national rules that restrict the free movement of goods, that are MEQRs basically, for the protection of health and life of humans, animals or plants, the protection of national treasures possessing artistic, historic or archaeological value, or the protection of industrial and commercial property. So these are very clearly defined exceptions that you can have. For example, a product that is a hazard to health. We have now we had, I don't know when you're watching this video cast, but we had in August 2017 a big scandal with eggs in the Netherlands where a certain product was used that was a hazard to the health of persons. And this is of course a good example of a situation where other countries can say, listen, your eggs are not welcome in our country, so we're banning your eggs, they're not being sold here. That is an Article 36 situation where you say, sorry, the protection of health of humans is at stake here, so we basically put a ban on them. Now, it's good to know that these kind of justifications can apply both in discriminatory and non-discriminatory situations. Yeah, so they can discriminate between, for example, Dutch eggs and eggs from Germany, because in Germany the problem doesn't exist, in the Netherlands it does. Yeah. Now, apart from those exceptions, there have also been two additional examples exceptions that have been developed in case law, in jurisprudence from the Court of Justice of the European Union, and those are the Cassis de Dijon case and the Keck case, and they will now be further explained in the last two slides. It's important to understand that this is only in non-discriminatory MEQRs. Yeah, so these exceptions are only possible when the MEQR does not discriminate. I will explain that in a second. Key distinction is that Cassis de Dijon is about so-called product characteristics cases. Yeah. So when the characteristics of the particular product are the reason why they are restricted. And the Keck case is about selling arrangements. And this has to do that there's a certain way in which the products are being sold, but it's not about the characteristics of the product itself. Yeah, so for example, your shop has to be closed on Sundays in our country, meaning that in that day we cannot sell any products, meaning it restricts the free movement of goods. Has nothing to do with the characteristics of the good itself, but it's still a restriction. Yeah, and then the question is that allowed, yes or no? So let's start with Cassis de Dijon. The case number you see on the top, 12078, so you can look it up. It's a really a landmark case. Again, a very important case that we expect you to know. It was about alcohol again. In this case, so-called crème de cassis. It's a French drink that anyone in France will know. Usually they mix it with a little bit of champagne, I believe, or some other bubbles. And this French producer of Cassis de Dijon decided to export this product to Germany, because the Germans also like a good glass. And the German importer wanted to sell this product on the German market, and then ran into trouble because he was not allowed to do so. Why not? There was a law in Germany, again, remember, MEQRs are usually national laws or other rules that restrict something. There was a law in Germany, and that law said that these kind of drinks such as Cassis de Dijon, called Brandwein in Germany, they need to have a certain alcohol percentage. I believe it was something like 25%. And Cassis de Dijon had less than that alcohol percentage. It had something like 15% or so, 15 and 20% of alcohol. So the reasoning was that, oh, sorry, my Siri is starting. The reason was according to the Germans, that this high percentage of alcohol, this lower percentage of alcohol that Crème de Cassis has, was actually a problem because German customers were not used to that. So they were not used to have a product on the market with a Brandwein that had such a low alcohol percentage. And this was confusing to consumers, and it was also potentially dangerous. They even claimed that it could lead to more alcoholism and so on, which is a bit of a twisted reasoning, but okay. Creative lawyer they had in Germany. So, second box, the German authorities tried to justify this law. It looked like an MQR on grounds of consumer protection. German consumer was not used to these alcohol percentages in Brandwein. Now, what was the outcome of the case? What did the Court of Justice rule here? Well, it established 4 points that we will now go through separately. First, it looked at whether there was not harmonization in this case. This is always the first step. What does it mean? It means that there's a European directive or regulation, but usually directive. Yeah, so if there's a directive that has harmonized the rules in this area, then you just look at the directive and you follow the directive. Yeah. So basically, it gets only more interesting when the situation is not harmonized, when there has not been legislation of the EU in the area. Now, that was the case here. So then we go on to the second step. The rules cannot be discriminatory. As I said, these 2 additional exceptions are only in cases when there's no discrimination. Now here, it's very easy to get confused. Also in light of what we said before about indirect discrimination and so on. The question here is that you look at the rule and you check whether the rule doesn't discriminate between products from different countries directly. Yeah. And you do that simply by checking whether the rule is applicable both to domestic products and to foreign products, and that it works in the same way. Now, if you do that, then you will see soon enough that in this case of Cassis de Dijon, there was no discrimination between German products and French products, because all the Brandweins had to have the same alcohol percentage, at least 25%. Yeah? So it's easy to get confused here. It very often happens that students think, hey, this is discrimination between the French, because the French wines cannot be accessed, cannot be sold on the market, and the Germans can. But wait, the alcohol percentage is the same. Yeah, it's the same for all producers, whether they're from Germany or elsewhere. So it's a non-discriminatory rule. Next step is their restriction needs to be necessary to protect a legitimate interest. Yeah, so here, again, there needs to be a good reason why the government restricts. And what are these good reasons? Well, it's more or less an open category. And so it has not been restricted by the court as to a certain number of key interests. But it's, for example, about consumer protection. And what we saw in this case, another example is environmental considerations. And there are some others that you can also look at if you want to know more about them. And then the last one, there we have it again. You almost can say as a Pavlov reaction when you're dealing with these cases, proportionality. There's always this element of proportionality. So the restriction should be proportional. Now, this is where it went wrong for the German government here, because what the court said is that this German law did not comply with the last point. It was not proportional, the restriction. And it said, listen, you may have this rule, and it might not be discriminatory, and it may even protect a legitimate interest, consumer protection, but it's not proportional to say you cannot sell these products in the German market. You have less restrictive options. For example, put a clear label on the bottle that says, German customer, please mind, this Cassis has less alcohol in it. And then we leave it up to the consumer to decide, with knowing this, that the percentage is lower, that he or she still wants to buy it or not. So that's, of course, a more proportional solution than a full ban of the product. And then we go to the last slide, and that is the other example the other situation where the court created an additional exception to this MEQR prohibition next to Article 36, and that was Kek, the Kek case. So, what was it about? Kek and Mitoir were two supermarket managers sold coffee and beer at a lower price than they had purchased the coffee for and the beer for, and that's a marketing strategy called predatory pricing. You might be familiar with it. It's often used by companies that want to fight their position, create their position in the market, and they sometimes temporarily sell their products for less than the cost price. And so everyone becomes their customer, and then they put the price up once this is done. But there was a French law, there we have it again, a national law, that said this is not allowed. You cannot have this technique in France of predatory pricing. And why would you have such a law? Maybe you were wondering that. Well, this could be the case because you want to avoid strong parties in the market killing competition by using predatory pricing. And so if, let's say, I start a new phone company tomorrow, Maarten Mobile, I don't have that money, but okay, and I want to start my market, and I want to sell my product, and then T-Mobile decides to offer similar products of what I offer for less than the cost price, and then T-Mobile will kill my business in no time. So that could be a reason for having such a law. So we end up at court. Again, of course, a preliminary reference. The other cases we discussed were also preliminary references, and you know that this is the bulk of the court's case law. That was something we studied quite in depth in the first part of the course. So the French court, where the case ended up, where Kek and Mitoir were complaining about this law, fighting this French law, referred the case to the court, and the court answered, or basically had to answer the question is, if the way in which a product is sold, and restrictions on the way in which a product is sold, also fall under the MEQR prohibition, or if there are exceptions possible there. And please note that this was not a Cassis de Dijon case, because at Cassis de Dijon, the law, the German law, required the product, indirectly required the product to change, namely to change its alcohol percentage in order to be marketable in the German market. But here, we're not talking about any change in the product. Yeah, it's about how the product is sold. Can we sell it for less money than it actually costs? That's called a selling arrangement. So the court had to decide now, in situations of selling arrangements, if there could be an exception to an MEQR prohibition. And the answer was, according to the court, yes, it's possible to have restrictions to selling arrangements. Again, there has to be no harmonization. Of course, that's a very logical first step. So we first check, is there a directive on selling arrangements or something like that? No. Okay. Then the rule cannot be discriminatory. So the selling arrangement rules have to be the same for national goods and foreign goods. Is that the case here? I'll give you 2 seconds to answer. Yeah, that's funny. That was my Siri. I didn't plan this. It has this voice automation activation function. I'll switch it off in the next video. But anyway, it said yeah, yes, but the answer is actually no. So Siri was wrong. So there was no discrimination here, yeah, because both the French supermarkets and the French people selling products and domestic people selling products, all these products were sold under the same conditions, namely that there cannot be predatory pricing, so no discrimination. And then finally, there needs to be, again, a proportional, there needs to be, the proportionality principle needs to be taken into account, yeah? So the restriction in the selling arrangement should not be excessive. Now, answer here, is it excessive? Does it actually lead to a full, let's say, limitation of Kek and Mitoir to enter the French market? Are they basically being strangled? Is it non-proportional? The answer here is no. It's not excessive, so it complies with the proportionality principle. Now, the actual outcome of the case is not so important, but that you know that these exceptions also exist for selling arrangements and that they're possible under these conditions is what it's all about. That was it for this week. Maybe a bit chaotic with all these interruptions by my phone and some difficulty in pronouncing certain words, but maybe that makes it also more real. I'm not going to redo this video cast. And should there be any unclarity, then we can always discuss them in our lecture. Bye bye.